Yes, Mr. Ganser.
May it please your lordships, I appear on behalf of the claimant in this matter. RWU is acting by his mother as his litigation friend.
Yes.
And I appear along with Mr. Ollie Percy and Mr. Alex Temple, instructed by bindments. Mr. Glenister, along with Miss Sian McGibbon, appear for the Academy, the respondent. My lords, the interveners are represented and they've submitted written submissions by Mr. Duran Seddon Casey and Ms. Nadia O'Mara.
Yes.
My lords, you will have seen that the interested party, the London Borough of Southwark, has played no part in these proceedings, and similarly today is not in attendance and has not put in any submissions of any kind.
No.
My lord, may I begin by checking with the court that it has the bundles, that the correct bundles that we were working from. There is a core bundle and supplementary bundle, and my lord, there is also a new evidence bundle, described as that, and the authorities bundle.
Yes.
And you should also have, my lord, the perfected skeleton arguments. They were perfected insofar as page references were updated on those.
Yes, well, I have to protest about this, that we prepare, or certainly I prepare, on the basis of skeletons lodged in advance, write on them, mark them and so on, and then to be told the day before the hearing that they've all been rewritten in respects which are not made clear is rather unhelpful. So have you plural got hard copies of the affected skeleton arguments, and are they marked up to show the differences?
We have hard copies, my lord. We emailed through the track changes, and as I understand it, the track changes were simply to a few of the page references which were amended as a result of the authorities bundle.
I think the page references were amended in relation to the core bundle and the supplemental bundle. It was helpful, but as my lord says, to get it a day or two before the hearing is not very helpful.
I appreciate that, my lords.
And if it's as simply as mechanical as putting in page references, it's difficult to see why it couldn't have been done sooner.
Yes. Well, there you are. If you have hard copies, could you please hand them up? But speaking for myself, I'm using the ones which were lodged a week ago.
The track changes. I can send you the track changes to show you when your page references.
Yeah.
My lords, we can hand up hard copies of the perfected, but we don't have hard copies of the tracked versions.
I'm in the same position, my lord. It's not the one I've handed you is not tracked. It's the updated page.
I can send electronically my lord and my lords. I'm sorry, copies.
All right. Yes.
That deals with the documents, my lord. In terms of there being any other preliminary matters, there was the application in respect to the new evidence, and the stage that we're at on that is that in respect of the statements on the part of the intervener and quorum, the statement that we rely on, there's no objection taken to that. There's objection taken to the remaining evidence, but we rely on that. We rely on, set out in our skeleton argument, that we invite the court to consider that evidence de bene esse. It doesn't go directly to ground one. There are two grounds in this appeal. In terms of ground two, which relies on ground one, it may be that it becomes necessary in terms of the argument that's made on whether conscientious consideration was applied in the decision by the governing disciplinary panel, but I leave it there
Yes.
at this stage. I think that is the most pragmatic approach at this point.
Yes. Well, subject to anything Mr. Glenister wants to say, it seems sensible that you can show us documents, if you must, without, at this stage, making any ruling as to whether you should be showing to us. Mr. Glenister's argument is that one has to consider the position that, as at the 24th of June last year, and the subsequent events are pretty irrelevant, but we think it's better that you deal with that in the course of argument rather than try to take a
Yes.
preliminary issue about it now. Is that all right, Mr.
Yeah, content with that approach.
Good. Right.
Thank you, my lord. That makes sense. In that case, I now turn to the appeal.
Yes.
My lord, this hearing follows on from the order made by Lord Justice Stuart Smith on the 19th of December 24, and for your reference, my lord, that is at Core Bundle 69, ordering a rolled-up hearing, considering that the issues raised were important and that the impact on the claimant and the Academy warranted urgency. Following on from that order, Lord Justice Singh granted Black Equity Organisation permission to intervene, and my lord, for your reference, that is at CB 71, and that was on the 10th of January 2025. The appeal concerns the judgment of Mr. Justice Fordham of the 8th of November 2024. By his judgment, and again for your reference, my lord, that is at CB 72 to 109, he dismissed the claimant's application for judicial review of the decision of the Governing Disciplinary Committee of, as your lord has just indicated, the 24th of June 2024. And by that decision, and your lordships have that within the core bundle at 245, the end of the core bundle, I will refer to the Governing Disciplinary Panel either as GDP or GDC. The GDP decided to uphold the principle of the Academy's decision of the 18th of January to permanently exclude the appellant, and this followed on from the matter being remitted to it by the independent review panel after the independent review panel quashed the decision of the GDP previously upholding the principal's decision. May I then start by outlining 4 reasons why this appeal is so important, my lord, and that goes to the issue of permission being granted and provides context as well. The first reason, my lord, is the most important is the impact, the immediate and life-changing importance of this decision to the appellant. He is, as you will have seen, at the time of the exclusion, he was 14. He's now a 15-year-old black boy from inner city London. Mr. Justice Fordham described this case as an anxious case, and by that he said that it was an anxious case in that it had within it troubling features. The appellant was subsequently referred into the NRM, and there is at this stage a positive reasonable grounds decision that he is a potential victim of trafficking, and that is in respect of his involvement in criminal exploitation, specifically county lines, as an excluded child, and we see this within the various guidance and policies, and that is also recognised within the judgment of Mr. Justice Fordham. He is at heightened risk of CCE outside the school environment. He was in his first year of GCSEs. His GCSE exams are now due to in this year, May 25, is due to sit them. And from having been described as a bright boy with great potential, he's now due to sit 4 GCSEs, which will be capped. He's out of full-time.
Sorry, which will be
capped. So that means in terms of the results that he can get on those. They're foundation level GCSEs. He is currently having one-to-one home tuition. And my lords, you may have seen from the statements that he has provided and the statements that his mother has provided, this has had the most serious impact on him in his education and in terms of his life chances. It's undeniable that the exclusion and the break that he's now had in his full-time education have damaged those. In her witness statement in support of the BEO interveners' submissions, Ms. Adiogan talks about the damaging psychological impact on children who are excluded, that they feel discarded, hopeless, distrustful. The child becomes marked. The Home Office guidance, and I will in the course of this appeal take you to the policies, recognises the devastating impact on victims, families and communities caused by exclusion. And as a result, there can be no doubt that that very serious impact on his studies, on his relationships, on his family, on his future is fundamental to him, and to some extent will be irreparable. No one has taken issue with that. That's the first reason why this is so important and has within it compelling reason to be heard. The second is the importance to the academy and schools more widely. Mr. Justice Fordham, in his judgment, set out that he accepted that Article 4 could be triggered in circumstances such as these. Obviously, his conclusion in the individual circumstances of our case was that it was only with hindsight that it was triggered, which is what the essence of this appeal is about. But he said that Article 4 could be triggered in circumstances concerning a school or academy considering permanent exclusion in the context of there being what are described as hallmark features or recognised within guidance and policies as common indicators or characteristics of exploitation in county lines, grooming. And he also set out in his judgment that in those circumstances, that means the protection duty is triggered so that those making a decision on exclusion must do so compatibly with that protection duty. And so in terms of the wider importance of this appeal, that protection duty attaches and must attach to frontline staff, recognising those indicators, and again within guidance and policies, my lords, education is key to that. The environment, the protective environment of the school. That also involves, when I say that, I'm referring to acting compatibly with the Article 4 protection duty, multi-agency working, sharing information on safeguarding. It involves, and again this is recognised within the various policies, that the most important aspect of this is keeping children safe. It is important in a wider context because of the growing rise and highly concerning rise of permanent exclusions and the rise of exploitation of children and county lines. And that, as I say, that schools are the most protective environment. And two other points under this second reason heading, and that is, it cannot be stressed enough, and it is recognised within Mr. Justice Fordham's judgment, that as soon as the child is excluded, the risk to him being out of the school environment dramatically escalates. And then the final point is that that means that the same frontline staff must consider, when they have before them a child with indicators of CCE, such that the credible suspicion is triggered, and with that the protection duty, they must then grapple with protecting the child in meeting that duty. There's a protection duty, and I'll go on to address you later in my submissions on the investigative duty as well, but essentially we're concerned with the protection duty at this stage. And that is not, that doesn't sit in the abstract, because alongside that, the school, the principal, the head teacher must consider the welfare of other pupils and the school community at large in informing and deciding on whether to impose what is recognised as the harshest sanction. It's described as a sanction of last resort of exclusion. So that's the second reason. The third reason...
Sorry,
Sorry.
just catch up.
Yes, third point.
The third point, the third reason, my lord, is the reality of how permanent exclusion and CCE impacts particularly black boys. And my lords, you may have seen within the evidence the reference to the school to prison pipeline. Both Mittal Raithatha from Quorum's Children's Legal Centre and Kehinde Adeogun from Black Equity Organisation testify within their statements to the reality of black boys in particular needing protection, and an aspect of that is that they are more likely to face adultification. They talk to the link between permanent exclusion and the criminal justice system, and that black children are disproportionately represented. Very significantly, Ms. Adeogun talks about, and I think this is also recognised in TDT by Lord Justice Underhill, about, in this context of CCC, that we're dealing with a process. So Ms. Adeogun says, CCE does not happen overnight, it is a process, with signs either ignored or wrongly attributed to the child, shifting blame. my lords, I won't take you to the reference now, but for your reference, I won't take you to the page now. For your reference, it is at SB 338. And she says, black children are too often seen as perpetrators rather than the victims of crime. She also says, which is a point that I've made in respect of the second reason and the importance for schools and academies, that CCE is also a consequence very often of a permanent exclusion. And the two other points that she makes are, first, the exploitation of young people into criminal activities is a public health issue. And she says the impact, that's the second point, the impact on individual families and communities is far-reaching and costly. And then, my lord, the fourth point, or the fourth reason that I rely on to say how important it is that this matter is granted permission for your lordships to decide the appeal substantively, is that county lines and CCE are a growing national crisis. So this is the wider crisis point. They are a growing national crisis affecting highly vulnerable children. And on that, my lord, we set out in our skeleton that research from Action for Children shows a 45% increase in referrals of children to the National Referral Mechanism between 2021 and 2023. That is the NRM, with 42% of those referrals relating to county lines. Home Office statistics show a 10% increase in overall referrals in just the last quarter, reaching their highest ever level. My lords, for your reference, this is in our skeleton at paragraph 4.3. Half of the referrals resulted in a positive reasonable grounds decision, which is what we have in this case. And of those, 52% resulted in a positive conclusive grounds decision. The Children's Society, which works with local authorities, the NHS and schools, estimates that 46,000 children in England are involved in gangs and 4,000 are criminally exploited in London alone. My lords, according to the Department for Education's most recent statistics, in the 2022 to 23 academic year, there were 9,400 permanent exclusions, which was an increase from 6,500 in the 2021-22 academic year, and that was the highest ever level. And the link between school exclusion and contact with the criminal justice system, and this is what I described before, is a long recognised phenomenon, sometimes referred to as the school-to-prison pipeline. In 2019, the National Crime Agency found that 100% of children involved in county lines had been excluded from school and reaffirmed the role of exclusion as a contributory factor. My lord, this was also raised in terms of the individual circumstances of this case before Mr. Justice Fordham, that effectively, when the permanent exclusion decision was taken, in this case concerning RWU, it is it's not an underestimating to say that that does and has represented a very significant crossroads in his life. And as BEO in its submissions have set out, has the most dramatic effect on the child. So those are the four reasons that I rely on.
Yes.
My Lord, now
Mr.
turn...
Braganza, we've discussed this, and we don't want to consider permission as it were a threshold point. We'd like to roll up the whole hearing in that if you now go on to substance, that's not because we've granted you permission. We'll decide at the end of the hearing how to handle the case.
Yes.
But Mr. Glenister, you don't object, do you?
Content with that approach.
Good, right. So you can go on to substance as though you've been granted permission, and we'll put that issue off till the end of the case.
Thank you, my Lord. So in that case, I now turn to the first of all, if I may, the procedural history, if you like, of the decision. So the procedural history, in terms of the key dates, is going backwards, if you like. That the application for judicial review was, as I said at the outset, was dismissed by order dated the 8th of November 2024. The decision that was challenged before Mr. Justice Fordham was dated the 24th of June 2024. That followed on from the reconvened GDP hearing on the 17th of June. That was as a result of it being remitted from the IRP, the Independent Review Panel, which quashed the decision on the 29th of May. On the 13th of May was the hearing of the IRP. The first decision of the GDP upholding the head teacher's decision was on the 18th of March 24, and this all stems back to the very original decision on the 18th of January.
It's a helpful agreed chronology.
Yes, that's right, Myra. And that is within the core bundle and sets out at 239. And my lords will have seen that the events that lead to the permanent exclusion are the previous 5 suspensions, which start just after half term on the 31st of October 2023. The 5 suspensions are, I'll take them briefly, and they're set out again within, you have them within the chronology.
Yes. They're also set out by the judge, aren't they? In paragraph 21.
Exactly. Yes, well, very briefly, in terms of the chronology of it, the suspensions begin 31st of October 23, that is one for 3.5 days, on the basis of the appellant repeatedly swearing at a member of staff, refusing to be taken to the reintegration room. The second suspension was for 1 day on the 15th of November 23, 2 weeks later, for jumping the Year 7 playground gate and running away. The third on the 27th, 12 days later, for 1 day and for appearing to be under the influence, speaking slowly, having red eyes, acting lethargic, and a lighter and a vape being found on him. On the 28th of November, he was brought to the academy by the police because there were reports about a group of young people smoking cannabis and throwing roof tiles off the balcony, and he was in his school uniform. That resulted in the 4th suspension on the 29th of November, when he was suspended for 2 days, and then the 5th of December, the 5th suspension, he was suspended for 4 days, including at that stage for sleeping. And then finally, the events on the 18th of January 24, when he was late to school and subsequently served, found to have cannabis on him, Rizzler, lighter, vape, and cash. That led to the permanent exclusion.
Yes.
My lord, the primary ground of appeal, ground 1, is that Mr. Justice Fordham misapplied the credible suspicion threshold for Article 4 as set out in TDT by Lord Justice Underhill, referring to Ransef and the 3 duties that Article 4, by way of positive obligations, impose. And that he did so, he misapplied that threshold, which is a low threshold in the context of the exclusion, where the Academy has a specific role and expertise in safeguarding a child, was undertaking a quasi-prosecutorial role and imposing a sanction that materially increased the appellant's risk of further CCE. And the nub, my lord, of what we say is that the indicators that Mr. Justice Fordham lists, and I will take you to those in a moment, as featuring in the circumstances of this case, were such that, taken with what are recognised to be common indicators or hallmark features of CCE, they were such that, taken together, they plainly crossed the threshold of credible suspicion. So that the Article 4 protection duty was triggered. Requiring the decision to be made compatibly with the Article 4 duties.
You've said that before, the Article 4 protection duty is triggered, and the compatibility point, but at some stage, speaking for myself, you're going to need to define what the protection duty would be for a school dealing with a PEC's decision. It's not entirely clear from the skeleton.
What is set out in TDT, and also in this regard, we adopt the submission.
Yes, but TDT doesn't define a protection duty for schools facing this sort of function.
But what TDT sets out, and the other Strasbourg authorities, specifically BCL, is that once the protection duty is triggered, appropriate measures.
Yes, exactly. But
so
that's precisely the question I'm asking about. What are the appropriate measures?
So the appropriate measures are that.
I mean, for example, it's dealt with in the intervenor skeleton at page 330 of the supplemental bundle. Some parts of your skeleton, it looks as if you're asking the court to rule that there's an absolute requirement imposed on a school not to exclude, as opposed to taking Article 4 into account. So I was left uncertain as to which way you were putting it.
We're not saying that there's an absolute duty. In the circumstance of this case, Mr. Justice Fordham found that if it were triggered, that he should not have been excluded. But what it does require is that the prism through which...
Did he find that?
Well, what we say is the prism through which that needs to be considered is the protection duty. So how do you protect the boy? What other safeguards can be put in place for the boy? Also weighing up the welfare and safety of the rest of the school, and ensuring also that proper inquiry is carried out. So, for example, if there's safeguarding concerns, working with other agencies so that the decision is properly informed before it's taken as to whether it should be taken.
Now, we'll come to the case law in a moment, but you are asking us to find that there was only one lawful decision that the Governor's Panel on Remission could have taken, namely to reinstate your client.
I'm asking you to find that the governors should have, when they were deciding whether to uphold the head teacher's decision, they should have acted compatibly with the protection duty, which meant they should have had in mind factors about protecting this boy. So, for example, knowing that the social worker had raised the A&E visits, knowing that should have triggered a heightened level of inquiry on the part of the governors. They should have considered that the exclusion meant he was at heightened risk, that had escalated of CCE. And so in light of that, they should have considered whether it was lawful for the head teacher to have excluded him.
Or what?
I'm sorry, my lord?
Or what? Exclude him or what? What would be that would be the ultimate decision, or was there some kind of middle ground?
They could have decided that he was to be reinstated. They could have decided, they could have given their decision with recommendations that pastoral support was allowed to run its course. That could have included that there was a trusted adult for him. They could have included
You're going too fast.
Sorry, these...
I'd like to write it down. Yes.
They could have decided that actually the time for the last resort hadn't yet come. And by that I mean that the other measures, as I say, that could have been implemented was either another suspension, or they could have explored more an alternative managed move, which was something that the head teacher had looked into. There is, within the documents that the head teacher put before the panel, there was email exchange about whether a managed move could be outside the area. They could have looked at that. But the first thing
they could have done any of these things, but they didn't.
No.
Are you pursuing the claim in the statement of facts and grounds for a mandatory injunction requiring his immediate reinstatement at the academy?
Well, it's right, that's what we sought, and we'd relied on that because it was the second time round that the matter had gone back to the governing disciplinary panel.
Yes.
I say, in the circumstances of what is known about this boy, that he should, yes, that he should be. That's the outcome, that he should be reinstated.
And that would mean an injunction carries the contempt sanction. So
Well,
the injunction would be saying to the principal and the governors, and perhaps also the teachers, unless you readmit this boy immediately, you will be sent to prison.
well, my lord, we'd sought that, as I say, we'd sought that in the court below. I don't pursue it to that level. I don't.
But the
pursue it to that
question
level.
that my
But I
lords
see-
were asking was, are you submitting to the court that if the matter goes back, which is the upshot of what you've just said, it would go back for a redetermination, the only rational decision that lawfully could be made by the GDP would be to reinstate, and it would be unlawful to maintain the decision to exclude? That was the question that was being asked.
My lord, what we know from the deliberation notes, I am answering. I have understood the question. I am answering it, but I'm coming to it from a few steps back. And the few steps back are that when your lordships considered the deliberation notes, you will have seen that the governors queried whether enough had been whether there was enough evidence about the emotional needs and the welfare of the appellant. And at one stage, the governors say, well, one of the governors says, I'm 49% and 51%. And that was without considering what in fact it ought to have known at the time, and if it goes back now, it will know.
Without, in other words, having the product of further inquiry.
Well, the duty under Article 4, this is one of the points that we make, required a higher level of inquiry. And if that higher level of inquiry were carried out and had been carried out, then we say, in fact, that upholding the head teacher's, the principal's decision, in light of all of those factors, yes, was not open to it.
Well, let's assume, for the sake of argument, they did go back and they made the further inquiry and they discovered the further information to which you refer. They would still have to apply the PECS test set out in paragraph 7 of Miss Justice Fordham's judgment.
Yes.
And that involves, as a second limb, what might be described as a balance, considering the interests of staff and children in the school.
Yes.
Are you going so far as to submit that, as a matter of law, that armed with the further information about your client, when they came to that balancing exercise, they could not come down as a matter of law in favour of permanent exclusion?
I think the difficulty is, my lord, that there were even further indicators than those before them, which were highly compelling indicators of how at risk this child was. And so, yes, they take into account, and they have to take into account the two limb about the persistent breaches and also serious harm to the pupil and also to the school community. But if that is weighed up against, and this is an answer to the previous question about PECS being the last resort, that must involve alternatives to the exclusion. So yes, we're saying, had that properly been carried out, the outcome should have been that he would be reinstated.
And the only lawful outcome.
On the basis of how at risk he was, yes, my lord. On the most striking features about this case, and they are listed by Mr. Justice Fordham, are that there was no history until the very rapid deterioration of his behaviour. So the red flags are up within this very short space of time. He had been previously recognised, profiled in earlier years at school, and for that had been involved in projects of being at risk. But all of a sudden, coinciding with his mother not being around, his key protective factor, he presents with a dramatic change in behaviour, being under the influence. He gets distressed during one of the later suspensions, I think on the 18th of January. And he's described by the IRP as a child in crisis. So the school is dealing with a child in crisis, where the interventions that have been put in place, the pastoral support plan, has not been allowed to run its course beyond the 4 weeks. And so, my lord, if you like, it's very early days in seeing whether had proper support or scaffolding, if you like, been put around for this child, whether he could in that way remain at school. His mother was back. He's described as being a bright child with great potential and charisma. And so weighing all of that in, together with the protective duty and the wider school community, and looking also at what we do have from the GDP's deliberation notes, that they seem very much to be wavering as to what they should do, but they waver without applying the protection, applying a protective focus. And it seems very much from reading those deliberation notes, and also putting them to one side, looking at the letter itself, which is very short in its reasoning, that had it been raised to them, this is a child who is at risk, PECS is a last resort, and if you do impose PECS, you are taking a child that is already highly vulnerable, and you are placing that child at a higher risk, that in fact,
Yes,
yeah. So I think, I mean,
you're arguing the merits. Nothing wrong with that, but you're giving us reasons, as you did for why you say the 24th of June decision was wrong. And I think your answer to the question, are you saying that the only decision that the governor's disciplinary panel could lawfully have taken was that your client should be reinstated? Is that a sort of rationality argument, that taking into account all the facts which you've argued, no rational body of people could have come to any other conclusion?
My lord, it is, but it is also that the point is the Article 4. It's making a decision that is compatible with Article 4.
All right. Well, let's have a look. You were alluding to TDT and Rant 7, possibly another case. Shall we have a look at what Article 4 requires?
Yes, my lord. So, shall I take you to TDT?
Yes.
In that case? So, TDT, my lord, is page 179 of the authorities bundle. And my lord, the facts are relevant insofar as they demonstrate the basis on which the court found that in fact the credible suspicion threshold was met. The claimant, my lord, I'm just reading from 179. The claimant, of Vietnamese national, entered the UK in a group of young men transported in a lorry. He was assessed as an adult and detained, although he maintained that he was 15. He was then assessed by the Traffic Boys Advisor at the Refugee Council, who concluded he was a child who had been trafficked. A pre-action letter protocol to the Home Office written by solicitors requested that he be released from detention.
I mean, the point in the head note about the facts is that the Home Office released the claimant without any safety measures being put in place.
Yes.
And it was held in due course that those particular officials were frontline staff in that context.
Yes, exactly, my lord. and that it had been drawn to their attention that there were concerns.
And the Court of Appeals said that by the time that the officials were referring matters to the NRM, they must have had enough information to be able to appreciate there was a credible suspicion, etc.
Yes, my lord. And the Court of Appeal found that the credible suspicion represented a low threshold, and that the distinction to be drawn mere allegations and those with sufficient foundation to call for taking of protective measures, and that that meant that having regard for the threshold that had been crossed where the putative victim's account was not inherently implausible, and that the credible suspicion concerned whether there was a real and immediate risk of being re-trafficked. And specifically, my lord, if you go to, it's page 185 of the bundle, and it's paragraph 13 onwards. Article 13 sets out Article 4, which provides that no one should be held in slavery or servitude, no one should be required to perform forced or compulsory labour. And then, with regards to the positive obligations, Mr. Lord Justice Underhill sets out the leading cases Ransef, and refers to the court saying there that there can be no doubt trafficking threatens the human dignity and fundamental freedoms of its victims, cannot be considered compatible with a democratic society and the values expounded in the Convention. And then going on, refers to, I'm now reading from paragraph 15D, 286, as with Article...
Yes, don't read out long tracks, Mr. Brigand, so we can read it. The italicised part of 286 of Ransef, cited by Lord Justice Underhill, is obviously important. It's not an issue. I'm interested in what this case tells us, if anything, about what the protective duty might involve.
Yes, my lord. So, first of all, at 17, my lord, you'll see the duties, the three headings, the systems duty, that's 17D at 188. You have that, the systems duty,
yes,
the protection duty, and the investigation duty. And then, my lord, if you go to 25, page 190, reference is made to the guidance and the frontline staff guidance. And then overview and summary begins at paragraph 30, 191. Yes. Where again, and specifically 32, summarising the obligations. And my lord, at 192, paragraph 33, the court sets out that the threshold is very low. So 33.1, there's an obligation under guidance on frontline staff. I won't read it out, I invite you to read that.
Yes.
And then, my lord, if you go to 37, this addresses the credible suspicion threshold.
Yes.
and specifically Lord Justice Underhill then deals with the real and immediate risk and what is meant by that.
Yes, that's 41.
Yes, and then through to 44. Sorry, what did you say?
Yes, I doubt whether any of this is in dispute.
My Lord, there's the reference, which in my submission, I think, and I hope that answers your question as to how far the obligation goes and what it entails. My Lord, if you go back to 186, I should have taken you to that part there. If you go back to 186 and paragraph 287,
Yes.
do you have that? So, bearing in mind the difficulties involved in policing modern societies and the operational choices which must be made in terms of priorities and resources, the obligation to take operational measures must, however, be interpreted in a way which does not impose an impossible or disproportionate burden on the authority.
Of course, when one looks at a case like this, some of the reasoning is directed to a state, and some is directed also potentially to individual authorities. Here we're talking about the GDP. Presumably also we would have to add to 287, taking into account what the statutory functions were of the GDP.
Yes. But that yes, and my Lord, that's obviously in the very important context that the GDP, in the same way as the principle, and this is something that featured in the IRP's decision, that they will all have to hand and should be familiar with the various policies. So the Home Office guidance on CCE, the guidance on keeping children safe, the guidance on mental health and behaviour, alongside the Academy's own safeguarding policies. So they are particularly expert and should be informed in assessing a child with repellent circumstances, the context, so that they will know in that role, they will know that indicators, as we have here, listed by Mr. Justice Fordham, and if you go beyond that, what would have then been known to them had it been, were it to go back to them now, that all those indicators are such that actually he should be dealt with, and he required to be dealt with as a child in crisis rather than a child to be punished.
All right. Do we get anything else from TDT?
My Lord, yes, if I just, so I've taken you to 32 and 33, and then the real risk reference to Raybone at paragraph 44. Yes, what you also get, which is really important, my Lord, because this is another characteristic that was recognised and referred to by Mr. Justice Fordham is the generic or specific evidence factor. And, my lord, you see that at paragraph 47 of the judgment. And then, my lord, in the same way, in TDT, there is reference to the high proportion of Vietnamese children going missing and the generic evidence. As I said, in this case, there was evidence from the previous support that the appellant had been given in his lower years of him being at risk, being recognised that he needed to be profiled because he was at risk of exploitation in county lines. So that is a further factor. And the other aspect of TDT, my lord, which is important in both the respect of ground 1 and the judge having erred in having concluded that Article 4 was not met, and also in respect of ground 2 and the consideration to be given, is with regard to paragraph 85 of TDT, where Underhill refers to the heightened duties for children who are victims or potential victims.
I'm sorry.
Sorry.
No, after you. You were taking instructions.
Oh, thank you. Thank you, Anna. Yes, sorry, my lord.
But I may have misheard you a moment ago, but I thought you said there was evidence of an earlier assessment of risk of your client, which at an earlier stage had identified him at being at risk of CCE. Could you give us a reference for that?
Yes, my lord. So if I start with the
Or maybe just the
in
best
the judgment.
reference. Maybe just the best reference.
Yes. if I
Is this
if
part
you
of
give me a
the evidence in the lower court?
I was just going to go to the judgment because the judgment specifically.
Yeah.
Is it 27? I don't know.
It may well
that
be.
one.
And there's also 25. Yes, my lord. Is that the paragraph you mentioned? It's the other actions.
No, sorry, I think it was particularly in regard to the risk of CCEs.
Yes.
Because there's two mentions of it, aren't there? There's at paragraph 27, which I think
Oh,
is
yes.
the first one, if I recall. And then the next one is the one at 40.
Yes, I was, my lords. When I was making the submission, I was speaking about the earlier support that had been put in place when he was in his younger years.
Yes,
But
that's
you're
what
right,
I didn't
there is
understand,
also,
because it's very clear what's said at the end of 27, which is on the 18th of January.
No, yes. So I was.
But it was the suggestion that this emerged at an earlier stage, which I hadn't grasped.
Paragraph 25.
Yeah. So,
Yes.
Well, these were all the programs that they had been put in place, the interventions, wasn't it?
these were earlier. So,
Yeah.
yes. So the suspensions were all in the second half term.
Well, the autumn. Yeah.
Yes, in year 10, and these were in earlier years. So that's the first indicator, if you like. So he has been.
You're saying that what's in 25 is an indicator of CCE, are you?
I'm saying that where it says in 25, Future Men is a program specifically tailored for young men at risk of potential gang involvement, criminal activity, or criminal exploitation, and the claimant was profiled to participate. So he's flagged as a boy who is at risk, such as to involve him in this particular program. That's the earlier one that I was, my lord,
Thank you.
addressing you on.
Thank you.
You're right. There's a specific one, and that concerns the cash, because again, common characteristics are presenting with drugs, which he did, presenting under the influence, which was also the case, and also presenting with unexplained cash. Now, you will have seen that what he said was different from what his mother said, and his mother prepared a statement confirming what she said. And even on that, my lords, I say that had this matter gone back and the GDP applied its mind to the protection duty, that even that as a conflict in explanation of cash is something that should have triggered concern and probing and inquiry.
Okay, we've gone
yes.
back to
No, it's
why the panel's decision was wrong, but
yeah.
You were going to show us cases about what the protective duty actually involves.
Yes.
Not what the threshold for engaging it is. We get that from TDT and RANSEF. But what are there any other authorities that we need to look at on what Article 4 actually requires if the protective duty is triggered?
My lord, if I may have a moment. When it's triggered, as I say, the reference is to appropriate measures so that they entail support and protection.
Well, in TDT, it was the measure, just to assist you, as I understand it, is that the Home Office were wrong simply to have released the individual without any kind of support, and which may have led to him simply disappearing as he did. Is there any other cases that identify what might
The VCL, my lords, and this VCL is at 432. Just before I take you to the detail of VCL, in answer to an earlier question as to the alternatives to imposing the exclusion, my lords, I'd suggested a number, but in addition to those, alternatives would be to consider moving him to another class, checking the times that he arrives and leaves at school. I spoke about, and there's reference within the evidence before the IRP as well, about having a trusted adult. carrying out searches on him, and giving him individualised education in the school environment.
There is, there's mention somewhere in the evidence about a managed move which didn't work out.
Yes. Yeah, if you...
The chronology says 1st December 2023 that the head of the academy contacted another school regarding a possible managed move, but that didn't lead to anything.
No. My Lord, at page 5 of the supplementary bundle, there's a reference to the managed move. That's just over halfway down. There were email exchanges as well that my Lord may have seen, where on one of them he's described I think as a great kid. The managed move. One of the managed moves, they come back and they say that they don't have the place available, and the other managed move breaks down because he's arrested for carrying a knife.
Yes.
Yeah. But there's another, which I'll find.
The judge deals with this, I think, in 34 of his judgment, page 87 of the full bundle.
Yeah. Yes, that's right.
The first part of paragraph 34.
Right.
I think,
yes.
my Lord, the other going back to the question before about is there only one answer, and what we say on that if the decision were quashed and it went back to the GDP. The other very important change is that when he was excluded, he didn't have. Not only did he not have the support around him that he has now, but his key support, his mother, was not there during a significant part of when he was then suspended. And so if the decision were quashed and it went back, and that is something else that should have, proper regard should have been had to, that putting in place alternative measures to the last resort of permanent exclusion would be alongside his mother, his protective key person, being there for him. And all of that impacts on the other ways by which exclusion could have been prevented.
Mother was away in November and December
Yes.
23.
Yes, when yes, exactly. That's on the chronology.
Yep.
And that's Yes.
That's the period of the suspensions, but not. She was back
On
by
the
the
18th.
time of the exclusion.
Yes.
Right.
Right. So if I may, before I then take you to VCL, yes, could I ask you please to go to the supplementary bundle, and this is the interveners submissions.
I thought you were going to
Because-
take us to PCL.
Well, it's just if I start with those submissions, because they answer your point, my lord, in terms of what measures, what is required, what the
It's
article.
page 330.
Yes, 330. And specifically, it's paragraph 14.2. And what Article 4, the positive obligation, would then have entailed. Having in mind as well 3. Again, that goes to the level of inquiry, whether to make a referral to NRM, and then we say added to that is inquiring more conscientiously and vigorously into alternative methods, alternative measures that could have been put in place.
So it's A to D plus that last point, is it?
Yes, ma'am.
You adopt A to D, do you?
Yes, my lord.
The first 1A, have regard in considering PECs to the role played by any CCE. Is that dependent on the credible suspicion threshold being satisfied in relation to CCE?
Yes, ma'am. Because
And if you fail on that point, the threshold isn't reached, is it?
the threat, as soon as the factors are such that there's a credible suspicion.
Of CCE.
Well, whether it exploitation, whether it's
Yes, but we're
CCE
talking
or
about Article
county
4.
lines or-
We're talking
yes,
about Article
in
4.
the-
Excuse me.
Yes.
Forced labour. What's relevant in this case is CCE.
Yes.
So the credible suspicion test, as applied in the context of this sort of case, relates to CCE, does it?
Yes, ma'am.
Thank you.
And specifically within CCE, yes, county lines.
Yeah, indeed.
Exactly.
Yes.
Exactly right. And yes, as a result of the factors that are set up by Mr. Justice Fordham.
Which is why you emphasise the indicators which have been listed as giving rise to a credible
Yes.
suspicion of CCE.
Yes.
But that's what the issue turns on.
Exactly.
Yeah.
Exactly. Against what is repeatedly documented within the policies and the guidance and the Academy's own policies about characteristics of CCE. Yes.
Could I just flag up one point? Guidance. There's a
I
lot.
keep saying guidance and not.
Yeah, forgive me. It's not a criticism. There's a lot of it.
Yes.
Some of it's Home Office. Some of it's Department of Education.
Yes.
We might need to know the relevant statute provisions under which the guidance has been made. For example, Department of Education guidance.
Yes.
Because that might affect the status of it.
Yes.
In decision making.
Yeah.
I mean, I have no idea at the moment how GDP is aware of Home Office guidance, for example? Depends who it's directed to.
Well, it's addressed within the judgment.
Okay.
So I'm conscious that I paused at VCL, and but I can take you to the judgment.
No, I'm not meaning to interrupt you. I'm just
No,
flagging
it's
it up
fine.
as a
No,
thing,
yes.
a matter which might need to be thought about.
Yes, yes.
help
No,
us.
thank you, my lord. I appreciate
I
that.
apologise for that.
No, not at all. It's helpful. And as I said, and I'll right. So, my lord. So VCL concerned the that's at page 432 of the authorities bundle. And in terms of the facts, the circumstances were that notwithstanding there having been a referral, the Crown Prosecution Service refused to discontinue proceedings, and it reviewed its decision to prosecute and concluded there was no credible evidence of trafficking. Significantly, my lords, when you look at 435, the legal representatives had dismissed out of hand the possibility that the victims were trafficking victims. And just pausing there, my lords, we say, to the extent that Mr. Justice Fordham in his judgment says, well, because of all these agencies did not refer.
Well, he was talking about two agencies, wasn't he?
He talked about the police and the local authority, the social worker, yes. Because they did not refer, well, going back, he says that if that were right, if it were right that Article 4 were triggered and the threshold was crossed, these authorities would have referred and would have recognised that this boy was a potential victim of CCE. And he makes that point repeatedly. And our point on that is it's not whether other agencies have or have not does not decide whether the credible suspicion
It doesn't determine it. Is it of any relevance? I don't think he put it quite as boldly as that, did he? I think he said it was of relevance, but not. It wasn't determinative, obviously.
From a reading of the judgment, he appears to place quite significant relevance on it. He does, yes, of course, he considers other matters as well, but he repeatedly highlights that, and as he does within his refusal of permission to appeal again. I think it must be right, if there are referrals, that will feed into the credible suspicion threshold, their referrals by others. But similarly, the fact that there aren't cannot be determinative of whether the question has been, whether the test has been met or not. And in fact, that's set out within VCL that the failure does not absolve the respondent state.
But in fairness, the duty isn't on the lawyer, is it? It's actually on the state, isn't it?
Yes. So the court's assessment and the general principles begin at 479. And the nature of the positive obligations is at 480, my lords, beginning at paragraph 150.
Is 156 relevant? And 154?
Yes, my lord.
Sorry,
Yeah.
153 to 154 plus 156. Some of it's very high level and some of it can be more specific.
Yes.
Well, this is obviously a very important case in criminal law that holding, I think for the first time, that for these young defendants to have been prosecuted was a violation of Article 4 and also of Article 6. And it all leads up to the section from 157 to 183. You build on this and say that the actions of the academy in bringing your client before the principal and then the panel and so on, it was quasi-prosecutorial. And so you say exactly the same principles as laid down in VCL should apply.
Yes.
That's how you put it.
Yeah.
Now, is there any is there any case, Strasbourg or otherwise, which has made that carry over?
For schools, my lord.
Yes.
No, there's nothing on schools, which is again why we say this is so important, because there's nothing. There's nothing I can take you to in terms of.
No.
There's nothing I can take you to saying that a PEX is a quasi-prosecutorial decision, and there isn't an authority that we have on that.
And is there any case which carries the principles of set out in VCL into any other context other than state prosecutions? For example, disciplinary, professional disciplinary, or that sort of proceeding?
My lord, we haven't found it.
No. All right.
Yes. So I am. Yes, I mean, there's nothing that I can take you to that's before the court currently. That's and insofar as that there are other Strasbourg cases on prosecution, there's none that I'm aware of, but I can check again of any sort of equivalent disciplinary process.
I think the Supreme Court said in cases like Uller and so on that it's the duty of domestic courts in this country to follow established jurisprudence in Strasbourg, but not to get ahead of the curve, if I can put it that way. Is that a fair understanding?
I mean, in this context, I'm not inviting this court to get ahead of the curve. It's very plain. There can be no issue that excluding a child permanently is the severest sanction that could be imposed, and the wider, which the court knows, the wider implications of that are so fundamental to the individual's life that my lord said, of course, as CPS, the decision to prosecute is very serious, and I would say that this, in fact, is more, if not as serious, because of its implications.
Well, to help, I only asked the question in the context of your submission relying on quasi-prosecutorial functions, but your case isn't actually dependent upon that particular submission, is it? If you have your protective measures point based on TDT.
Yes.
So you may not need to push at that particular door.
Well, I don't if you're with me, my lord, that the indicators were such that Article 4 was plainly triggered, and you're with me that actually Mr. Justice Fordham's evaluation was wrong in that it was triggered, then in my submission, it is plain from the very curt decision letter, and also if you read or if you don't, the deliberation minutes with it, that duty, the protection duty, is not made out. It's
just to help me follow what you're saying. The quasi-prosecutorial argument based on VCL, if it were to succeed, as my lord observed a moment ago, in the real world it led to Section 45 of the 2015 Act.
Yes.
It led to a defence.
yes,
In other words, you can prosecute, but the prosecution's not going to succeed. So that line of argument, if it were to be transferred to this context, would lead to no exclusion. But your other way of putting the case is based upon what we saw in the intervenor submissions at page 330, the 4 points there, which don't depend upon the quasi-prosecutorial argument, and you add the fifth protective measure. It might be said that's a less adventurous way of putting the case.
yes, and we adopt that as well. My lord, just finally on VCL, what I would also highlight is that it is set out, and this is paragraph 159. I invite you to read that, please. And that it sets out early identification is of paramount importance. I'm just finding the...
Yes.
And 160.
All right, now, Ms. Braganza, looking at the clock,
Yes.
it's 12 o'clock, so
Yes.
you've got an hour to go, roughly. In
Yes.
fact, I would like, for personal reasons, to rise a few minutes before 1 o'clock, but that won't come out of your time. But in rough terms, you can expect to address us for half a day. How are we going to spend the next hour? We've so far looked at TDT and VCL, and you've told us why the case is important, which it certainly is, but we haven't yet looked at the judgment of Mr. Justice Fordham.
Yes, that's
And perhaps we should go
I think
there
we should.
next.
Yes, no, I agree. I think, my lord, it is fair to say that there were a number of questions raised by the court, and I think that's why we.
Oh yes, you
strayed.
did.
I had planned to tell you the grounds and take you to the judgment, and in fact, as I was explaining the grounds to you, it went off.
Right.
So let's
let's
go to the judgment. Yes.
Well, we can blame ourselves.
Well,
I
no.
include myself. Lord Justice Jeremy Baker has been extremely silent, but you've had a lot of questions, both from me and from Lord Justice Holgate. We'll try to restrain ourselves and let you make some progress.
No, I'd prefer you not to, my lord, so that your queries are addressed. Yes,
I always did when I was in your place. A sort of lay bench which sits there and stares at you is not very helpful. Right.
Right. Okay, so if I may then take you to the judgment. The judgment begins at 74. Just in terms of the legal framework, that is set out at paragraph 5. I can take you, if you need me to the authorities with section 51A of the Education Act and the relevant regulations, but the judgment sets it all out comprehensively, and it's only the very last conclusion that in fact we take issue with.
Yes.
Everything else we adopt. We adopt all the factors that are recognised. We adopt that it's an objective test. The assessment is for the court. We adopt everything other than the very final evaluation on the basis of the indicators. So if you'd like me to, I can take you to those sections in the authorities. Otherwise, I rely on what is set out in terms of each of the 4 stages, and also what Mr. Justice Fordham says about effectively there being 4 reviews: the review of the head, the review of the GTP, the IRP reviewing, and then the court reviewing. I think maybe what would be helpful is that there is also reference to how I've always repeatedly generically termed the guidance, the various guidance that there is. My lords, that guidance on child criminal exploitation begins at 29. Of the judgment, that's at 84. So up until that point, you have the facts all set out.
What we see at 29 is actually the Academy's own guidance, is that right?
Yes, that's right, my lord.
Thank you.
In particular, that if there's small CCE shared with DSL with a view to referring to the NRA.
And presumably you rely upon the indicators
Exactly.
towards the end of the first paragraph.
Exactly. And my lord, they mirror the Home Office toolkit guidance and the exploitation guidance, and that guidance I'll take you to in a moment.
But this is their own guidance.
Yes, absolutely. And as I say, it reflects, yes, it reflects what's set out in the various other policies and guidance. I rely on it to say, yes, matching what we know about this child with what they say in their own guidance, the threshold was crossed. So you've had an opportunity to see that, and then again these list of common characteristics are referred also as hallmark features, and where they feature within the various the Keeping Children Safe in Education and the Home Office Child Exploitation Disruption Toolkit are all set out and detailed at paragraph 30 of the judgment.
Yes. Tell us when you get to something that you disagree with.
I don't, my lord. It's just the very end.
Yes.
So, what I what I take issue with, but I'll address you on that because it's more relevant to ground 2, is the data sharing and knowledge of these hospital admissions. But for the purposes of ground 1, the most important paragraphs, my lords, begin at 61.
Yes.
So, 60, the legal point about relevance. And Mr. Justice Fordham, he sets out there in the indented section how it's to be interpreted, but in fact, the way that he then puts it in the first line of 61, we entirely adopt and agree with, that I can agree that the PEC's decision should only be taken compatibly with the duty owed by the school. He says, I would agree GDP could not fail to reinstate if by the time of its consideration or reconsideration of reinstatement an HR duty was owed by the school to the pupil. And then I'm jumping down where he says, if, and I emphasise if, there were a protection duty, it must not be contravened. We accept that.
Where? You're jumping to where?
That's just beneath South Gloucestershire Schools Appeal Panel. That's the...
Oh, I see, yes.
He says,
right.
Yeah. And he then gives the comparison of Article 2 in the same way by reference. The Academy could not lawfully order someone to leave a school building and face the imminent prospect of being murdered at the school gates. If the appropriate measures within the scope of the public authority's powers involve an Article 4 duty on a school not to impose, then that would become a statutory duty. Again, no issues taken with what he then says.
You agree with the way he puts it in the last sentence of paragraph 61?
Where I could agree with her on a case-specific basis that there may be cases where the same circumstances which would trigger an article have become, to which regard must be had. Yes, they're relevant. I mean, I think what he sets out at the end of 60 is how he framed it during the hearing, where he says having regard. That's what he suggested, having regard to any protection duty. I think it's more accurate to describe it as he does at 61, which is acting compatibly, so not just...
Yeah, but then you need to spell out what you mean by acting compatibly. That's just high-level language.
Yeah. I mean, he says it must be an obvious, relevant consideration.
But that's at the end of...
Yes.
Which is arguably consistent with what he'd said at the end of 60.
Yes.
What I don't understand in 61 is how what he says at the end, the obviously relevant consideration, is consistent with the earlier passage just above South Gloucestershire, because that seems to imply that in some circumstances you could have an absolute duty to reinstate. I don't understand how the two sit together, and he doesn't explain it.
I mean, I have to say I had
You had the same problem?
Yeah, I did. 61 I didn't, yeah.
I don't know if South Gloucestershire is in our bundle. Does that supply the answer?
It isn't, and I don't think it does. But I have to say I didn't understand 61.
Well, we're in good company
then. So then he says, I don't think I can add any more to 61 because it's right. He says it has to be done compatibly, and then it's a relevant consideration. Then 62, he agrees, and he defines appropriate measures within the scope of the public authority's powers to protect an identified individual. And he says it's an evaluation that has to be done objectively. Again, there's no issue on that. And then 63 to 64 lists some 14 or 15 indicators. And I'm not going to list them again for you. You have them there. But that's the number that they come to.
I've forgotten what the 3 steps are. Where does he? The first step is a legal point about the relevance of the Article 4 positive obligation.
Yes.
What's the second step?
Is how to assess it. That's 62. Submissions.
Whether the court is taking the decision itself as opposed to reviewing what the decision maker thought about it. Yeah. And then 63, the third step, is on the supposition that it's an objective test for the court, which he assumes in your favour without deciding it. He then applies that approach.
Exactly. Well, he says, I'm with you to this point, and these are all the factors.
And then 65 is where it comes to an end, isn't it?
Exactly. Exactly. Yes.
So are you really attacking 65 and 66?
Yes, because 65, he says, the Academy was alive to the issue, was right to have concerns. The IP was satisfied the Academy had taken CC into consideration. Concern was flagged up to the police on the day of the PEC's decision. And then he says, and this is where I say this is sort of the first reference to it, but it was never suggested to or even argued for the GTP or the GTP at stage 4 there was a positive Article 4 duty, still less such a duty owed by the Academy. Talks about the MASH referral, again, that's another indicator. He doesn't treat it as that. Sorry, I should make clear. That's my submission on that. And then at 66, again he says, so if my legal logic were correct, it would mean that the local authority and the police owed a protection duty. So he's relying on that again, and on the circumstances known to them to make an NRM referral, and neither the local authority nor the police considered that a CCE positive obligation threshold had been crossed, nor they think it was crossed. And then again he says it, neither the local authority nor the police told the Academy duty was triggered. It was a MASH referral. The Academy was entitled to act with the other authorities and to share the information, especially given that the local authority and police are the designated first responders. And again he says no NRM referral was made until the 19th of August. And so his conclusion is, I've gone over the page. There was, in my judgment, no Article 4 trigger. And And he
Yes.
comes back to this very finely, my lords, at 83. Because in his refusal of permission, we in our grounds raised ground 1. And so if I could ask you to look at 83
Yes.
specifically, it's 5 lines from the bottom of 108 that he starts.
The other proposed ground. Yes.
Yes, exactly.
Yes.
Before I bring those threads then together, you have within the judgment, you've seen that the Academy's own policies and guidance. May I just ask you to turn to the guidance that we've put within the authorities bundle? My lord, first of all, there is...
Well, of course we can, but if you're only looking at paragraphs which Mr. Justice Fordham has cited, it does save time to take them from the judgment. But if
Yes,
you need
then
more,
that's fine. Then I
if you need more context, then
no, they essentially say what he set out in terms
Yes.
of the characteristics. They're the same characteristics that are listed. The point is that yes, they were policies that were before the governing panel. The governing panel should be expected to be familiar and have applied those. So we say that based on what is known by way of common characteristics, based on what were accepted as common as characteristics that this child was displaying, in the context of the frontline staff that we're concerned with being education providers, informed by their policies on safeguarding, keeping children safe, and based on the very low, the accepted low threshold, we are plainly in the remit of beyond mere allegation. Plainly in the remit of this not being described as not inherently plausible, not inherently implausible. So that the evaluation of the court below that the threshold was not crossed was wrong, in the same way as in TDT it was concluded that the court had erred in not finding the threshold crossed. In the same way we've set out, referring to a Frié, where the court held that the evaluation by the court below was wrong. In that same way, we say the evaluation here was wrong. Those are my submissions on ground 1.
yes.
I don't think, unless your lordships have any other questions, which I can.
No.
Thank
Right.
you very much, and I'll just check. Right.
Ground 2.
Round 2. I can take round 2, I hope, relatively briefly. the first point is that if you're not with me on ground 1, that is the end of ground 2. If you are with me on ground 1, then ground 2 is a very short point as to the nature of the consideration that the GDP was required to apply. It involved, as provided for by paragraph 259 of the guidance on exclusion, conscientious consideration. But that conscious consideration had to be carried out in a way that was compatible with the Article 4 positive obligations of the protection and investigation duty. So simply, for example, simply saying, well, there's something of concern as to his needs, his emotional needs, and not probing more in my submission is not compliant with that heightened level of...
Can I ask a simple question?
Yes, ma'am.
If you succeed on ground 1 and you get to ground 2, it's all about the way in which the decision was taken. Is it at the heart of your submission that one needs to look at CCE risk, putting it at its lowest?
Yes.
Did the GDP look at CCE risk in its determination?
If you look at the letter, my lord.
I mean, is it your case that they didn't?
No. What they said, the letter, my lord, is a yes, they didn't, and it's not simply CCE on the cash, for example. It's the whole picture.
Yes, I understand that. But my simple question was, did they consider CCE at all? As opposed to, yes, they did, but this is an argument about how they did it. But I may have missed something.
I'm just looking. So the letter is at the core bundle 245 at the end. So the decision itself.
I mean, a little litmus test, for example, is you've taken us to the internal policy of the academy and the indicators of CCE. Did they apply that policy?
No, my lord. Well, they had. Sorry, to be accurate. The matter was remitted to them as a result of a question about the policies and what they had. And at the beginning of the deliberation notes, they raise whether they've addressed all the individual aspects that were treated as shortcomings by the IRP. And amongst those was whether they had access, whether they had performed the policies. And then I think there's a reference to saying, yes, they're at the desk. But I'm just looking at the decision letter because I want to be sure.
Yes.
So looking at that, I think, my lord, the closest that they come to it is at the bottom of 246. They say family or other domestic circumstance. They don't talk about the extrafamilial concerns. And then there's the
Who's Miss Suleiman who's making submissions?
She provided a statement. She's a representative. She's not legally qualified, and she works for a charity, BLAM, assisting with exclusions.
Right. She was making submissions based on SEN and the code of practice applicable. So there was focus on that, but did anyone raise the topic of
Yes.
CCE?
Yes, they did, my lord.
Okay.
And I think we've got it's within the various references are in the reply skeleton, and there are I think they're in the reply skeleton. If you bear with me.
Yes.
Actually, I think they're in the main skeleton.
Okay.
There was repeated reference because she raised the link, breaking the link before the punishment is imposed. Ah, yes. So the skeleton. The factors are raised at paragraph 28. Sorry, if I just have a moment, we've definitely listed all the page references where every time she mentioned grooming. I'm just before I go on to that, to conclude, I can't see anything in the decision letter itself, which is a 246, and so the other document that we have is the deliberation notes, the deliberation minutes, and on those, that's page 4 of the supplementary bundle, my lords, and it is raised. But maybe it's raised in the questioning rather than the deliberations, because they speak about so they refer to having the policies, and I'm looking at page 5 of the supplementary bundle. We've met, the chair says, second entry by the chair, we've met all the areas that were highlighted. And then they speak about the interventions.
Yes, there's minutes of the hearing, and obviously not a transcript, but there's quite an extensive note of what was said in tab 2, page 8.
The main one. Right, we have it. Thanks to Mr. Temple. I'm sorry, 22. It's paragraph 22 of the main skeleton.
Right.
Yes, sorry. So those are all the references of exploitation having been raised. And when you have that to hand, looking at the deliberation notes, all they say I mean, they don't really, because they talk about emotional needs, and they talk about the MASH referral.
Is it the top of page 15, supplementary bundle?
No, they don't. 15, yes. So there's nothing in the deliberation notes, and there's nothing in the decision letter. So then going back, yes, and then after that, that cross-references to the first of our page references at paragraph 22 of our skeleton. And all the other references are, again, to when exploitation and grooming is raised. But it's not grappled with in the minutes of their deliberations or the letter.
Is your point in simple terms that the IRP, having expressly raised this point, which was effectively the reason it was sent back to the DP, it wasn't expressly grappled with at the meeting?
Yes, my lord.
Or indeed, you would say by implication. Can I just ask you at this point, you at the very outset of all of this, you set yourself, well, probably by invitation, quite a high bar to say that the only rational decision they'd considered would be reinstatement, etc. Effectively, you're saying this is a decision that is an unlawful decision because it's unreasonable, because it failed to take into account matters which they should have done during the course of the last meeting. And on that basis, you say it is an unlawful decision. Is that right?
Yes, but and also it's not compliant with Article 4.
Yes, yes, I appreciate that.
Yeah.
That's all the whole context of it.
Yeah.
Do you actually need to go further than that to say the only rational decision is one that's in statement?
No, I don't think I do. I mean, and
No, I'm just.
I'll rely on both. If you're not with me, that's the only outcome. Then that it goes back.
And I appreciate why you set yourself, because of course you say the urgency, etc., of a young child, etc. In education, yeah.
I mean,
fully appreciate the reason why.
It's been a year now.
Yes, no.
Could I ask a question following up from my Lord Justice Bean? Going back to the supplemental bundle, page 15, he drew attention to the passage at the top of the page. Now, as my other Lord has just observed, this was a final determination following a sending back, where the CCE risk issue was flagged up by the IRP. So it may be material to see how that issue was tackled on behalf of your client
At the IRP?
at the final hearing.
Yes. Yeah.
And what we see at the top of the page, unless I've missed something, is a reference to a risk of exploitation. It doesn't look, and it may not matter, but I just want to be clear about it, it doesn't look as if it was being said, actually, exploitation has been going on. and that explains what he did in the past.
I just want to be sure, my lord, in answering you that I'm right in what I'm saying, because it's certainly, there are three documents that you have. You have the hearing minutes, you have the deliberation notes, and you have the decision.
Yes, I understand that.
So those two, there's nothing of that. So it's just the hearing notes.
Yes,
the
but
hearing
the
notes,
what
right.
one sees in a decision letter is reactive to what happened at the hearing, which is why I'm looking at the hearing.
Yes.
As my lord was.
Yes, but so I'm just checking. I think that is right.
I mean, just to share with you my understanding. I mean, I see all the evidence about what's going on, for example, in the autumn, leading up to January and going into the next year, his association with particular youths.
Yeah.
But we're looking at CCE, and at the moment it looks as if the representative was talking about a risk of exploitation, not that he had been exploited or trafficked already. That may not be fatal, but I just want to make sure I've understood how it's being put.
I think that's right. But can I just also make the point, my lord, in answer to the first part of your question, that the way that county lines, the way that it manifests itself in the indicators, that you won't necessarily have any evidence of adult involvement. It might be peers. It's also recognised within I think it's the Home Office toolkit, that children are often very reluctant to disclose. So it's all of that. So,
well, I've picked that up, but obviously
yes.
we've gone long past that now in these proceedings.
Yes.
And there it is. The matter is sent back for this issue to be addressed.
And it's
there's no evidence that there was any inhibition about talking about the subject if it was appropriate. or have I missed something?
Did the IRP specifically mention the issue of
yes.
child criminal
Yes,
exploitation?
it did. It's this.
In the judgment, isn't it? It's paragraph 42.
Well, and the decision letter is at 114. Ah, right. I have the reference from the deliberation notes. Let me just 108. Oh no, this is the IRP.
Yes.
Sorry. No. Okay. So.
In fairness, the IRP couldn't have been much clearer in that sense.
So 114 and 115.
Paragraph 42 and 43. Page, sorry. 6, 2, 6, 7, 8.
Where's the reference to CCE?
Is it
7.
7?
Oh.
And then if you look at the... And also paragraph 43 as well.
So the references I have are 108, 104 and 105 of the supplementary. Bottom of 108.
The IRP found a number of defects in the original Governor's Panel decision, failing to take account of matters which they should have taken account of, one of which, subparagraph 7, is child criminal exploitation. So they send the matter back for rehearing, and it's mentioned, but only to the extent at the top of the page, page 15. Yes.
So they say in the second 115, the IRP in the second paragraph says, discussed whether the head and the governors had taken his vulnerability to child criminal exploitation enough into consideration. And then if you jump down,
So this is page.
SB 115.
Thank you.
Second.
Thank you.
Sorry.
This is the IRP, isn't it?
Yes, the decision of the IRP.
But I mean, it's in fairness, the judge had that firmly back because he sets it out, doesn't he?
Yeah.
In particular, at 43,
Yeah.
it's sent back for what they call procedural impropriety.
Yeah.
For that issue to be further considered. And they actually say at the bottom, the panel balance the needs of children, etc., etc. Question whether his background, vulnerabilities, etc., have been given enough consideration.
In the IRP decision letter, I don't know if it assists, but I can give you the references where there is mention of past profile risk of gang exploitation and then grooming and the A&E. But I think the most important paragraph is what they conclude on page 114.
Yes.
I don't think I can take that any further.
All right. If you're right, and the the decision of June 2024 was unlawful and has to be quashed, I think you accept, rightly, if I may say so, that it's not a case for a mandatory injunction, so it would be a case for the Academy to have to reconsider the original decision. They would then be acting on the facts as now known. Supposing you're wrong, and supposing the appeal is dismissed, what other recourse does your client have? Is the local authority under a duty to him to consider the broader question, not whether he should be readmitted to the respondent academy, but what duties are owed to him more generally? Can't be right, can it, that he simply has to be taught out of school for until he's no longer of school age? Have any other proceedings been taken?
Yes, my lord. There's the Section 19 duty in the Education Act, and it's pursuant to that duty he's currently having some tuition, and my solicitors and his mother have been pressing on with that. Obviously, having on his record a permanent exclusion significantly impacts on him being taken in any other mainstream education. He wants to return to the academy. Mm-hmm. The other duties, and that's in the new evidence as it happens, there's email exchange about previously there being a Section 17 assessment under the Children Act. But at the moment, in terms of his education, that's the current position. On the in respect of the county lines aspect, you have that in the new evidence, the positive reasonable grounds decision. One thing that I flag that in my submission is striking is that the positive reasonable grounds decision refers to concern about exploitation dating back to November 23, which is when he had his earlier suspensions, which would mean if it is concluded that if there's a positive conclusive grounds decision, and that recognises that he was a victim of grooming and county lines exploitation during the time that he was suspended and excluded, query whether the impact by that on the exclusion. But in direct answer to your question, my lord, it's Section 19.
Yes. All right. Can we break off here now?
Yes. I don't think
you may have finished, but let's see. We'll return at 5 to 2.
Okay.
If you, or in accordance with the Lady Chief Justice's recent practice note, Mr. Percy, want to have a few minutes then to wrap up, that's fine, and then we are likely to pass the baton on to Mr. Glenister.